Hello, good morning, everyone. Hi, hello, good afternoon to everyone who's watching the video today. And I'm back. My name is Sanjeet Bhatia on another session with you guys for the case laws for CLAT and AILET and any other law entrance exam that you're going for right now. So as we've been doing it for a long time now, we've been covering a lot of case laws and cases and legal newses that have been going all around the country for a long period of time now. Hello, Praveen. I hope everyone is doing great. So I come live for you guys on this channel on Monday, Wednesday, and Friday at 12 p.m. Right? My name is Sanjeet Bhatia. I am a National Law Institute University graduate and also a law mentor for you guys. And I will be covering the case laws today. And if you want to go and check out the other videos that we have made, so do like, share, subscribe the channel, and you can find a playlist on the channel itself. You can find the videos that I have made so far too. Okay, so hi Richa, hi Praveen. Hello everyone. I hope all of you are doing great and you are in great health and you are preparing for your law entrances just right now. Okay, so going before we move ahead, the basic that I say, please like and share the video. That is something that you can do, doesn't cost you anything. Okay. Okay, so Rama asks me, what is the schedule of YouTube law sessions? Like, on what days do you cover what, like legal CA cases, etc. So Rama, I make sure that I'm discussing right now for this week. I have changed the schedule a little bit, but I keep legal newses as my Monday. And then we cover some of the case laws or some any other topic from the legal point of view on Wednesdays, and on Friday I do a value added session which can be related to anything. It can be related to your CLAT exams, what you can strategize, how you fill your OMR sheets, what are the options that are available to you except NLUs or any other law schools that are you looking forward to. So all of these things are covered in this manner. Okay, so that is it. So please like, share, and subscribe, and then you can join our Telegram channel also. That is under the name of CLAT@Pratham. Coming to the next point is that if you're looking for personalized mentorship or counseling, you're not able to understand how do you want to go about and you need someone to guide you through, definitely you can give us a call on 5x9 75392. This is the number to get in contact with us, and you will be mentored properly for any exam. It can be DU-GMAT, it can be CLAT, AILET, as you know that we have law mentors from national law universities. So you can definitely get in contact with us and we will make you understand how to go about your exams too. Okay, and if you need any other international education help also, we help students going to the Ivy Leagues and other universities. So if you are planning to get into any top 200 universities all around the globe also, you can get in contact with us. Now, coming to the case laws for the day, that is the Krishna Lal Chawla versus the state of Uttar Pradesh. Now, this case has been a very, very important case for vexatious litigation, right? Because as you all know, there are a lot of fake cases that are being filed in India on a regular basis. So it's better that there are judgments regarding this in the judicial system so that there can be effective justice system. Okay, so Manan asked me retaker batches. Okay, Manan, you can contact us on 5x9 75392 and I'll be able to guide you better there. Okay, so now, we were discussing the case of Krishna Lal Chawla versus state of Uttar Pradesh. Now, what happens in this case is that there was a division bench of Mohan M. Shantagora and R. Subhash Reddy. Okay, these are two justices who were taking care of this case. Now, this case was against a vexatious complaint, right? Which is like a fake complaint. You can go with by that word also. Now, the bench, what did they say? That they were expressing their concern, right? Because there need to be a proper structure to scrutinize such complaints at the initiation itself. कि मतलब जब ये complaint file हो रहा है तभी देखने का है उसको, right? So that is their point, right? That these kinds of complaints should be seen when they are being filed itself. So that is something that you have to understand that was being said in this case. Now the bench has said, and I also quote that the trial judge has a duty under the Constitution and the CRPC, that is the Criminal Procedure Code, right? So you have to understand what does CRPC do. It gives you a code, right? It is a procedural code, right? What does it mean? That there is a procedure to take the criminal ahead in the court and all the proceedings, how the charge sheet has to be filed, when what happens after an FIR, an IO is being appointed, and all these procedures that are related to the criminals, right? The Criminal Procedure Code, which gives you a punishment under the Indian Penal Code, right? So what is the procedure that has to be followed by someone who's booked under that act is mentioned in the CRPC. Now what happens there is that it is there to identify and disposal of frivolous litigation at an early stage by exercising substantial and to the fullest extent the power conferred on him, right? So the trial judges have these powers to take care under the Constitution and the CRPC that these frivolous litigations are just cancelled out on the existing and the earliest level as much as possible, right? Because he has the power in him to do that. He's being conferred with that same power. So you have to understand that this was being said in the case of Krishna Lal Chawla versus State of Uttar Pradesh. Coming to the next video was Rajat Sharma versus Union of India, that is the Farooq Abdullah Article 370 case. Now this was also a very, very important case. So all the people who are going for their CLAT 2022 have to make sure that these cases are being taken care by you guys, right? That is really, really important that you read up all on these cases. And I'm revising a lot of cases for you guys that we have been teaching for so long, so that there is a revision of these important cases again. Okay, so now there is a bench of Sanjay Krishna Kaul, right? Justice Sanjay Krishna Kaul and Justice Hemant Gupta, right? They imposed a 50,000 rupees fine on the petitioner, which we called a cost, right? So if you ask any litigating lawyer, they will tell you the word for this is costs, right? So the cost was rupees 50,000. That is basically a penalty on the petitioner, right, for filing a PIL, that is a public interest litigation in the court, seeking initiation of proceedings against the former J&K Chief Minister, Mr. Farooq Abdullah, right? Now, if you would have heard about Mr. Farooq Abdullah, so after the Article 370 in Jammu and Kashmir, he's been in a major issues with the ruling parties and all the things that he's been grounded for a period of time. He's been out of the media coverage also, if you see. So there was a lot going on with Mr. Farooq Abdullah at that point of time. Now, what happens was, because the PIL, the person who filed the PIL was seeking initiation of proceedings against Mr. Farooq Abdullah for his pro-China comments over the abrogation of Article 370 of the Constitution, right? As you all know, there has been a lot of decisions taken by the ruling government, and they have given the same regarding Article 370 also. Now, what did the court say in this part was that the dissent from the government's decision cannot be said to be seditious, right? अगर आप गवर्नमेंट के डिसीजन से अग्री नहीं करते तो ये कोई seditious act नहीं होता है, right? So sedition is also a crime, right? If you just like instigate people to take against the ruling government and things of that sort, is considered to be seditious, right? You are threatening the people's emotion and making them to go ahead and attack and do things of that sort. So it is being said that the dissent from the government's decision cannot be said to be seditious. So the court was of that view, and they also put a cost on the petitioner that you are just filing it because for the sake of doing it, and it's not to be considered seditious, and he was given a fine also. So you can see that this was a proceeding that was done in the court, and you can see that the judges take a reasonable decision in such cases. Chaliye. So coming to the next part is that Patrika Mukim versus State of Meghalaya. This has been a very, very important case, right? As you all know that there are a lot of people who are being charged under the criminal cases, right? So that they just get inside the jail and they've been booked in non-bailable offenses, so that obviously if you are going against something, right, they can file like the government has the power to file a complaint, a criminal case against you, and you'll be behind the bars, and it's just an easy way out, right? So now this was what was said in the Patrika Mukim versus State of Meghalaya, was that the free speech of the citizens of this country cannot be stifled by implicating them in criminal courts or criminal cases, right? So it's simple statement, nothing very, very surprising about it in our country, but definitely you can read that the court is saying such things. Now there were two justices. There was a division bench, Justice L Nageshwar Rao and Justice S Ravindra Bhatt, right? They quashed a criminal case. There was a criminal case that was against the editor of the Shillong Times, right, Patrika Mukim, right, which was under section 153A, 500 and 501 part C of the Indian Penal Code of 1860. Now what happened in this one was that the court observed that the free speech of the citizens of the country was being stifled by using these criminal cases, right? And unless the speech has the tendency to affect the public order, they cannot be implicated in such cases. ठीक है, अगर भाई public को feel हो कुछ ऐसा कि वो कुछ जाके करें ऐसी एक्टिविटी और पब्लिक ऑर्डर खराब हो उससे और उनके स्पीच से ऐसा कुछ हो रहा है, अगर ऐसा कुछ भी नहीं हो रहा है, तो you can't implicate them in criminal cases, right? Now, you have to see what is being said in these sections respectively, right? कि इसको मिस पैट्रिक मुखर्जी को क्यों इन्होंने इम्प्लीकेट किया क्रिमिनल केस में, क्या क्या चार्जेस लगाए उनके ऊपर, अब आप वो देखिए, राइट? 153A, the section that she was booked, the first section, it said that she was promoting enmity between different groups on the grounds of religion, race, place of birth, residence, language, and doing acts prejudicial to maintenance of harmony. So she was basically disturbing the public order according to the sections that she's been filed under. Now, 500 says that the punishment for defamation, right? That gives you the punishment for defamation. Now, 505 talks about statements conducting to public mischief, right? That is, you will read mischief in your law of torts also, and it is also present under the criminal arena also, right? It is also a part of the criminal law. So this was the statements conducted to public mischief. Now you can read the definitions that are being mentioned there, but it is basically to publish or circulate any statement, rumor, report which incites the public to just go against the public order, right, or commit any offense against other classes, right? So then it shall be punished with imprisonment. Okay, so these kinds of things are being covered in the Patrika Mukim case, and you have read 3 more sections of the Indian Penal Code, that is 153A, 500 and 505. Coming to the next case for the day, that is the state of Goa versus Fauzi Imtiaz Sheikh, right? This was for the appointment of government officials as election commissioners, right? Now, this was said to be a mockery of the constitutional mandate, right? So that is being said here. Now, calling to the appointment of the law secretary of the government of Goa, right? There were a member IAS of the State Election Commission, said disturbing the 3-judge bench of R.S. Nariman, Justice B.R. Gavai and Justice Rishikesh Rao, that such appointment of government officials directly under the control of the state government is considered to be against this constitutional mandate that was contained under the Article 243K of the Constitution of India, right? So this is what is being said in the state of Goa versus Fauzi Imtiaz Sheikh. Coming to the next case, that is Democratic Reforms versus Union of India. There was no interference with the scheme of the sale of electoral bonds, right? So now electoral bonds are something that these political parties give to the people who go and give their money to them, right? So this is a scheme, right? So now there were three judge bench that was sitting on this case. So the ex-CJI of India was on the bench, as you know, Justice S.A. Bobde, that is Justice Sharad Arvind Bobde. And the next one is Justice A.S. Bopanna. And the last one was Justice V. Ramasubramaniam. Now, they said that they will not interfere with the scheme of the sale of electoral bonds with the political parties, right? That it allows the donors of the political party to maintain anonymity, which is not healthy for a democracy. ठीक है जी. So as they were challenged कि the people who are donating this to the political party, they're donating money, they have the right to stay anonymous, right? That's the kind of policies that we have in our country, that they are allowed to have an anonymity to be maintained. So definitely that is something that they have seen, and they challenged it, but the court said they cannot interfere with such sales of electoral bonds. Now, the court even said that the scheme provides anonymity. It is intended to ensure that everything happens only through banking channels. उन्होंने कह दिया कि anonymity maintain करना is okay if because everything is happening through a banking channel. So if they want to check, they can check. So that's the kind of thing that they are saying in this case, right? So no cash can be given to the as a donation to the political parties, obviously, and they're saying that if they are going for electoral bonds, it can definitely happen through the banking channels. I'm really sorry, apologize for this. Coming to the next part is the Sarvanan versus State, that the condition of deposit of amount cannot be imposed while granting default bail or statutory bail, a very, very small case. You can see that there was a bench of Justice Ashok Bhushan and R. Subhash Reddy, and they said about the statutory bail under section 167(2) of the CRPC, conditions of deposit of amount cannot be imposed in such cases. Now, Dr. Naresh Kumar Mangla versus Anita Agarwal, there is no embargo on it to transfer to the CBI. Now, the Supreme Court has observed in this case that there is no embargo on it to transfer an investigation to CBI after the submission of charge sheet. Okay. So that was being said in this case also. Now, Saurav Yadav versus and others versus the state of Uttar Pradesh was that the candidates belonging to reserve category are eligible to file general and open category vacancies also on the base of merits, right? So that was also being said in this case कि अगर रिजर्व कैटेगरी के कोई इंसान को जनरल कैटेगरी या ओपन कैटेगरी की कोई भी वैकेंसी मिलती है तो वो उसमें अप्लाई कर सकता है, right? So that is what is being said in the Saurav Yadav versus State of Uttar Pradesh case. The Supreme Court has observed that the candidates belonging to the reserve category are eligible to fill general and open category basis of merit only. ठीक है जी. Now coming to the next case is that if you are looking for getting in contact with us, do give us a call on 559-75392, and you can definitely get a personalized counseling and mentorship from us. And we'll be continuing the video on Monday itself, and we'll come up with some new legal affairs, and then we will continue with our session on Monday itself. So I hope every one of you stay safe, use your masks and hand sanitizers, and make sure you are maintaining the social distancing. If you are above 18, do get yourself vaccinated. Okay, thank you everyone. Take care of yourself. Stay happy, stay smiling, and definitely see you on Monday again.